Good afternoon, and welcome to our weekly webinar related to coronavirus legal issues. I'm Pete Jones, a partner in our Syracuse office, and as always, I'd like to start with a word of encouragement. I know this is difficult. It's been difficult for everybody, but I continue to be impressed with the resolve, the passion, the commitment of people. It's a beautiful sunny day here in upstate New York, hopefully wherever you are as well, and welcome to our webinar. Today we're going to spend some time talking about essential services in New York and the Attorney General's inquiries regarding whether people are in compliance with that. Following that, we're going to spend a little bit of time with Katie Anderson, an update from Albany. Aaron Torsello is going to talk about leave documentation under the Families First Act. Rick Weber is going to spend a few minutes talking about product liability, especially for those of you who are retooling your operations. And then we'll finish up with Erica Wood talking about the Main Street lending program. So we will endeavor to get to your questions to the extent we can throughout this next 45 minutes. But if we're unable to get to your questions, please feel free to call the bond attorney with whom you work, and we'd be happy to talk further with you. So with that, I'd like to introduce my partner, Andy Bobreck. Andy is a partner in the labor group in our Syracuse office, and Andy's going to talk about essential services and operating under the current executive orders in New York State. Andy, take it away.
Thanks, Pete. Thank you, everybody, for attending. I echo Pete's sentiment that we wish you the best. We know this is a difficult time. I, like my partners and colleagues here, just been beyond impressed with the work and dedication and skill that our clients have been showing throughout this crisis. And, you know, again, you have my encouragement too to hang in there. I think we do have some reason to be optimistic about some of the trends that we're seeing, notwithstanding the really devastating loss that so many have experienced along the way, and still some tough times ahead. But I think we have reason to be encouraged at this point. So as Pete mentioned, I do want to talk about a few things. The first would be new guidance that came out from the Empire State Development Corporation last week on the 9th, on Thursday late. This guidance, again, is something that has been evolving. It's something that we've continued to monitor closely, and we just want to give you a brief update on this. If you're not monitoring the ESDC's website, we encourage you to do that. Again, they're changing this guidance fairly frequently, and all of it goes back to, are you an essential business or not? And if you're not, you need to cease operating. And it's hard to believe, but it's been, I think, over 3 weeks now since Executive Order 202.8, which was the 100% reduction, was issued. And hard to believe that much time has gone by since then, but it remains in place. The governor's indicated that's expected to remain in place until the end of this month at least, barring further extension. And there were a few just quick takeaways that I wanted to mention and for your reference. So if we could move to the next slide, thanks. So this guidance, I think in general, there was some broadening of certain categories of essential businesses. A few notable things that I saw in the manufacturing area, which is something that I think wasn't too difficult to extrapolate based on the prior guidance, but it now expressly states that if you're manufacturing any parts or components that are necessary for essential products, you know, that part of your business is essential as well. I did note that they added automotive as a specific manufacturing category, and so if my business manufactures a part or component for that industry, I am essential too. Another addition to this guidance now allows for the delivery of remote orders at non-essential entities. So again, even if I'm not essential, I can fulfill remote orders, so orders that come in by phone, by email, by some other means, not in person. And so long as they only have one person present on the site to fulfill those orders. Also, we saw clarification allowing for remote instruction by public and private schools, as well as for certain fitness classes, but with the caveat that still there are no in-person classes permitted. Finally, I think a notable takeaway from the most recent guidance is clarification on the construction industry, what is essential, what is not essential. If you are in this industry, I would encourage you to read through the guidance, and if you have a question, to work with your bond attorney on this. This is an issue where we've seen quite a bit of development and change since the inception of these executive orders. And right now it really boils down to, are you in this now limited essential classification? And if you're not, you need to, in short, take whatever steps you need to be able to safely suspend work and then cease performing the construction work if you're non-essential. Concurrently, if you could move to the next slide, thanks. We saw a new executive order over the weekend, now the 16th, that has been issued. This is something certainly notable in the course of my labor and employment practice concerning essential businesses and their operations. I know Katie Anderson has been following this, like many other issues, very closely for the firm and our clients. And Katie, did you want to just provide a quick overview here of what we saw in 20216?
Yeah, so 20216 is it's about face covering. Those are the words that are used in the order. Basically, that employers are required to provide employees that are in direct contact with customers or members of the public with face coverings. Now, noticeably, the use of the word face coverings is vague. We do not have guidance at this point from New York State as to what face coverings are allowed and what face coverings are acceptable. Presumably, masks are acceptable, but beyond that, at this point, we don't really know much more. We do know that employers have to pay for face coverings, and we do know that they have to wear, that these employees have to wear the face coverings when they're interacting with the public. So imagine a store clerk or imagine a receptionist. Those are the types of places that a business or a not-for-profit entity would have to provide such face coverings. This executive order, it's effective on Wednesday, so tomorrow at 8 p.m., excuse me. And it also comes with some teeth. Again, this can be enforced by local governments. This can be enforced by local law enforcement as if it's a violation of Public Health Law Sections 12 or Sections 12B. Those carry fines of, under Section 12, it's fines of up to $2,000. Section 12B, it also carries misdemeanor charges that can be filed. So those are really important things to know. And when we know more, we will be able to, tell you more.
Thanks, Katie. Yeah, I happened to be watching the governor's press conference on Sunday when this came out, and I think during the press conference he mentioned face masks specifically, or a cloth mask of some kind, and so that got me thinking a little bit about what might be compliant. As you know, we don't know yet. I did hear that there might be some guidance coming out on this issue that we'll keep an eye on. Inevitably, the question I think a lot of us will get from essential businesses are, well, what can we do if it's masks, for example? Where can we find masks? They're very hard to get right now. I think that's certainly a fair point, and I think it remains to be seen. I know that there are healthcare institutions that have trouble lining up masks right now. So again, looking at other options that may be available consistent with this directive and guidance that may be forthcoming will be key. I think from my perspective, at the end of the day, let's make the very best effort that we can make. Let's take all appropriate precautions that we can take to protect our employees from exposure, while keeping an eye on compliance at the same time.
Hey, Andy, just before you leave that, we're already, getting questions from people, about, what it would be. And again, we're not exactly sure, questions about reusable masks and, washing them and, compensable time for washing, and whether they, multiple face coverings would needed to be provided. And I guess, I'll offer a comment and then let you comment as well. But my thought is we start where you just did, that, we do the best we can with what we know. And then these second order questions, which will inevitably arise, will need to be answered to the best we can. To the extent that multiple, coverings can be provided and meet the requirements of the order, we'll have less concerns about the, the laundering and things like that. But those are the kinds of questions that I think people are asking, and we just have to work our way through it with the best information and the best judgment we have as the guidance evolves. Thoughts on that? Or
Yeah, I agree, Pete. And I think there's not necessarily going to be a one-size-fits-all answer for these situations. It really does require us to take a look on a case-by-case basis. How's your operation set up? Is there even interaction with the public? Is there ways, if you can't find a mask or some other appropriate protective gear, is there some way to limit exposure? Other precautions that we can take. It's notable to me that the executive order uses the term direct contact. Doesn't define what that means, but if we can avoid direct contact, or if we don't have someone who's public facing or customer facing, I think those are things that we'll need to analyze along the way too. And there is guidance from OSHA dealing with these issues as well, which I think is important to keep in mind in terms of using PPE, how it needs to be used, and precautions that need to be taken. So let me talk a little bit about what we've been seeing in terms of enforcement. I know my colleagues would say the same thing, in that I have seen definitely a tick up on the enforcement side of the executive orders and really focusing on essential businesses. We've received and assisted our clients with several inquiries from the Attorney General's office, as well as inquiries from various staff members of the New York State Department of Labor, seemingly having been repurposed to now focused on COVID and essential operations. The presumption being that either a member of the public or an employee has made a report, perhaps not understanding that a particular business may be essential, and that now the government is investigating these issues. And what's typically happened so far is that there'll be an email that will be sent to one of the principals or a leadership position at the business or entity inquiring about their status. And we've seen a clear pattern in terms of the questions that are being asked of these essential businesses. So we wanted to include that today. This slide and the next slide are the questions that have been asked of these businesses. I think it's important to also recognize that typically the demand has been made to answer these questions and provide this information in very short order, in as little as 24 hours time. So I think if you are a business that is essential, that you're continuing to operate right now, and especially if you haven't received a confirmation from the ESDC, this is something that I think you want to take a look at and give thought to in advance of, well, how would we answer this? How would we address these questions? So that you're ready if and when you should get that contact from state officials. And hopefully in most cases, it'll be a fairly routine matter, but not everything's perfectly clear when it comes down to this issue. And you'll need to assess the information that you provide in responding to this, along with the continued assessment that you make for your business and organization, that irrespective of our status as an essential or non-essential business, we continue to safely operate and protect our customers, protect the public, and protect our employees. Again, what it really focuses on are things that you would think of, the questioning. It's first and foremost, are you essential? It's notable to me that they're really focused on the list. Are you on the list? And by list, they're referring to the specific industries and sectors within those industries that have been deemed essential. Not that your business name is on a list, but they seem to be indicating a fairly narrow view. If you're on the list, good. If you're not, then you're not. And if you're not on that list, you better go to ESD and get designated as essential. Concurrently, if they're looking for you to make your case why you're essential, and having those facts marshaled beforehand, I think will be important. And then finally, and just as important, is an inquiry about what protections are you and what initiatives are you taking to make sure that your employees are protected from COVID and from exposure, in drilling down into those specific steps that you're taking as an entity to protect employees, consistent with guidance that is out there through state government and through federal government. And an additional point where we've seen particular focus from investigators is on the notion that, hey, even if I am an essential business, those non-essential parts of my business cannot continue to operate. So that's the example of the manufacturer who makes toys as well as defense equipment. Well, the defense equipment clearly is essential, the toys aren't. You can continue the essential piece, but not the non-essential piece. And concurrently, the other area of focus that we've seen is where still, even for an essential business, you still have to make sure that those who can work remotely do so. So we've seen them testing that, so to speak, and focusing on different areas, and the issue of, hey, can this entity work from home rather than being physically present at the work site? And again, that's not going to be a uniform answer each time. It's really going to depend on how your organization is set up and the role of these other people supporting that operation. Pete, that's all I really wanted to just kind of flag for this. Again, we wanted to provide these questions so attendees could see them and give them consideration.
Andy, thanks. That's very helpful. And I think, two quick points. One is that I think it is very useful if people have thought about this ahead of time and have the information assembled. But it's also useful in terms of how you should be operating and what the scope of your operation should be. If those answers don't flow fairly easily, then perhaps the analysis needs to be done irrespective of whether there's an inquiry or not. That should be the sort of thing that people are evaluating continuously. Are we essential? Who can work remotely? To the extent that people can't, what are the mitigating measures we can put in place? And are we comfortable that we're only operating in-person operations in accordance with the essential needs as defined by the executive orders? Okay, I'm going to now turn to Katie Anderson. Katie is in our Albany office, has been following the developments from Albany and periodically updating us on these webinars, and within the firm more than periodically, I would say always. So in any event, Katie, please take it away.
All right, I'll make this fast. We'll try to keep this short. So this week, the thing that's been notable is that we appear to be reaching a plateau in New York of COVID cases. So this is good news. This means that what we've been doing is working, and this means that hopefully we can now start to transition to getting things back up and running. So the governor, as some of you may have heard, is teaming up with the governors of Rhode Island, Delaware, New Jersey, Connecticut, Pennsylvania, Massachusetts, Massachusetts, they're setting up a regional group of these states, how they are going to reopen the economy and reopen things in a way that makes sense and in a way that is helpful. And so that they're not, trying to cut each other off. It doesn't make sense for all restaurants to open up without restrictions in New Jersey when in New York they're still closed. So that's the logic behind that. So expect over the next few weeks we are going to be seeing some, a lot of movement on that issue. At the same time, you're getting pushback from the president on that same issue. We could be looking at some constitutional challenges that are going to be coming up. Turning to what happened in the past week in New York, besides the face mask issue, there was Executive Order 202.14. This extended New York pause to April 29th, meaning that all schools and businesses will be closed until April. All non-essential businesses are to be working remotely until April 29th. Another thing that's important to look at is that there are now fines. There are fines for individuals who go to gatherings. Gatherings don't have a definition. Executive Order 202.10 says that gatherings are non-essential gatherings of any size. And 202.14 says that fines of $1,000 attached to gatherings. So at this point, still keep your distance from people. We all know that it would have been nice to see people at Easter, but these are fines that are going to be enforced by local law enforcement, we believe. Additionally, it's worth looking at, there's one more enforcement mechanism for all executive orders, in addition to any other enforcement mechanism. A violation of any of the executive orders is punishable as a violation of Public Health Law 12-B subsection 2. That's important because that violation is either punishable by a fine of up to $2,000 or imprisonment of up to 1 year. So that would be a misdemeanor charge. So that can be laid on top of any other charges brought pursuant to these executive orders. So that will be all for this week in Albany, and we'll be back next week with more and more.
Katie, thanks. Appreciate the updates. A lot going on. A little less, I think, these days, and hopefully, less and less over time. Let's turn now to Aaron. Aaron Torcello is a partner in our Buffalo office in the labor and employment area. We had received a lot of questions, and we are continuing to receive a lot regarding the Families First Act, documentation of, the leave entitlements. And so Aaron is going to anticipate those and answer a number of them. Aaron, take it away.
Thanks, Pete. As Pete mentioned, we've been living with the Families First Coronavirus Relief Act, or the FFCRA, as I'll refer to it throughout the next few minutes, for a couple of weeks now. We're having a number of questions about implementation. But in addition to that, one of the basic questions that we've been receiving is, how do we document these leaves? What type of documentation do we need to substantiate our entitlement to the tax credits? Because this is a new aspect of paid leave that we're not used to dealing with. So we thought it would be a good idea to talk about some of the basics concerning documentation during our weekly webinar. So it's just a very quick roadmap of what we're going to talk about over the next few minutes. I want to give Rick and Erica enough time here. I want to first go over very quickly what the leave entitlements are under the FFCRA, just as a refresher, as a reminder of the types of leaves we're dealing with. And then I'll turn to what the documentation requirements are. This segment is really focused on the FFCRA. If you have questions about New York State's paid sick leave law, contact your favorite bond attorney for those. And This segment is going to be a very broad strokes overview of the documentation that you should be keeping. So if there are any specific questions you have about what you want to institute as an organization, again, contact your favorite bond attorney to go over those. So very generally, the FFCRA requires employers to provide paid leave benefits under the Emergency Paid Sick Leave Act that entitles workers up to 80 hours of paid sick time where they're unable to work for certain COVID-related reasons. And the second aspect of the FFCRA is the Emergency Family Medical Leave Expansion Act, or expanded FMLA, as I'll tend to refer to it throughout this segment. And again, that entitles workers to certain paid family medical leave. So more specifically, with regard to the paid sick leave benefit, there's 6 categories of paid sick leave. I'm sure you're all familiar with them, but just as a quick refresher, because it'll be helpful as we're talking about the documentation that you should have for each one. The 6 reasons are: the employee is unable to come to work because they are under a federal, state, or local quarantine or isolation order that's related to COVID-19. The employee has been advised by a healthcare provider to self-quarantine due to COVID-19 related reasons. The employee is experiencing symptoms of COVID-19 and they are seeking a medical diagnosis and therefore they can't come to work. So those are reasons 1 through 3. Reason number 4, the employee is caring for an individual who is subject to an order of quarantine or isolation, or they've been advised by a healthcare provider to self-quarantine. Reason number 5, the employee is absent from work because they need to care for a child or children where that child's school or place of care, daycare, is closed, or the child care provider is not available. And lastly, the 6th reason, the employee is experiencing any other substantially similar condition that's been specified by the U.S. Department of Health and Human Services. That's been the least utilized out of all of these, but I have to mention it. And then under the expanded FMLA leave benefit, an employee can be eligible for up to a total of 12 weeks, although only 10 weeks of paid leave, if the employee is unable to work, including telework, because of a need to care for a child or children whose school or place of business is closed. So as a quick recap, and the reason that I want to talk about the benefits that are allowed is because this really relates to the amount of tax credit that you can get, that you're entitled to as an employer. So if an employee is absent for reasons 1 through 3 that we just talked about, you're eligible for 2 weeks of paid sick leave, or a maximum of 80 hours at 100% of your regular rate, with a maximum of $500 per day, or $10,000 over the course of that 2-week period of time. So an employer's tax credit is capped at $10,000 for an employee who is absent for reasons 1, 2, and 3 under the Paid Sick Leave Act. If an employee is absent for reasons 4, 5, or 6, you still get 2 weeks or 80 hours of leave, but your pay is capped at $200 a day, or $2,000 over the course of that 2-week period of time. Again, if you're an employer who is looking to get the tax credit for that paid leave, you're capped at a $2,000 tax credit. And then lastly, if you are taking leave under the expanded FMLA Act, again, you are limited to, an employee is entitled to 2/3 of their regular pay rate, up to a maximum of $200 a day, or $10,000 in the aggregate over the 10 weeks that they are paid under the expanded FMLA provisions. So given the economic stress that businesses are facing in this uncertain time, the FFCRA provided for tax credits to offset the costs of these paid leave benefits. I'm going to talk very, very generally about what the tax credit allowances are. If you have specific questions about the tax credits, reach out to your favorite bond attorney, but given our time restraints, I just want to talk very generally about what's available. So under the FFCRA, you can get a tax credit for the full amount of the qualified sick leave wages, as well as the qualified family leave wages, plus any qualified health plan expenses, because you have to maintain health insurance over the period of that paid sick leave or expanded family medical leave. So you can also take a tax credit for any health insurance related costs that occur over the period of that paid leave time. The tax credit is only available for any leave taken during the period of April 1st, 2020 through December 31st, 2020. In order to obtain the tax credit, there has to be sufficient documentation submitted to the IRS to substantiate the need for leave over that period of time. So with that, we will turn to what the documentation requirements are. So before you provide paid sick leave or expanded FMLA to an employee, that employee really needs to provide to you written documentation substantiating the need for leave. This ensures not only that the need for leave is legitimate, but it also allows you to collect that tax credit when you submit your application to the IRS. So with regard to what you need in that written documentation, there's some basic information that you need, but depending on the type of leave that's being requested, there may be some additional documentation. So I'll first go over what the basic information is that you need to collect, and then we'll talk specifically about some of the requirements that you need if connected to some of the more specific types of leave. So generally, you want to collect from the employee their name, the dates for which the leave is being requested, a statement of the COVID-19 related reason the employee is requesting leave. So again, it's got to correspond to one of those 6 reasons under the Paid Leave Act or Paid Sick Leave Act or the expanded FMLA. A statement that the employee is unable to work, including telework, due to that reason for leave. So if we turn to some additional documentation requirements for some of these specific reasons. Remember, I talked about there's a reason we're going through 1 through 6, and that's because if you are asking for leave under that first reason, under the paid sick leave benefit, that is, the employee is requesting leave because they are subject to an order of quarantine or isolation, your written statement must contain the name of the government entity that has issued the quarantine or isolation order. So I'm located here in Buffalo, so was it the Erie County Department of Health? Was it the Niagara County Department of Health? What Department of Health or governmental entity issued that order of quarantine? Additionally, you can request, although you're not required to, I would advise that you do, where it's available, a copy of the order of isolation. If the employee has requested leave for that second reason, that is, they have been directed by a healthcare provider to self-isolate, and we've been seeing this most often, the written statement has to identify the name of the healthcare provider who advised the employee to self-quarantine. Similar to reason number 1, you as the employer can ask for a copy of a medical note or a doctor's note where the healthcare provider has advised the employee to self-quarantine. But you don't have to. Again, I would advise that you do if it can be provided. If the employee is requesting leave to care for an individual who is subject to an order of quarantine, you will need to have the employee tell you the name of the individual who's being cared for, the individual's relationship to the employee, as well as the government entity who's issued the order of quarantine or isolation, or if it's the situation where the the family member has been directed by a healthcare provider to self-isolate, then you'll want to get the doctor's note from that family member's healthcare provider. And then finally, if the employee needs leave to care for a child who's not in school, the employee needs to provide the name and age of the son or daughter, the name of the school that has been closed, and a representation that there's no other suitable person to care for that child during the need for leave. If the employee is caring for a child who is over the age of 14 years old, the employee has to indicate what special circumstances requires that employee to care for that child. And again, you can ask for documentation concerning the closure. And then the IRS has some additional record-keeping requirements that you will need to be aware of in order to claim the tax credit. So in addition to the information we just talked about, you also have to keep documentation and records showing how you determine the amount of paid sick leave or expanded FMLA wages that you paid, and how you determined what the employee was eligible for. You'll need to keep track of the related healthcare expenses that you want to claim the tax credit for. And then any copies of IRS Form 7200 or IRS Form 941, which relates to your quarterly tax filings, you'll need to keep copies of those as well to substantiate the tax credit. And with that, I'll turn it back to Pete if you have any specific questions.
Thanks, Erin. There are questions. I don't think we've got time to answer them all. Maybe this is something we'll put another information memo out on. We're also getting, a fair number of questions on the masks, and obviously that's very new. I think we'll put something out on that as well in terms of, trying to give people additional guidance as it becomes available, and, to the extent not available with the current interpretations. I want to turn now to Rick Weber. Rick's a partner in our Syracuse litigation practice group. And Rick had a few comments to make about product liability issues, labeling issues, things of that nature. Take it away, Rick.
Thanks, Pete. I want to keep this short and brief, make sure we stay on target here. If you go to our website, I had a quick info memo that was up on this. Kind enough to put it on the screen as one of the attached things here. We are experiencing really a great movement in the country of manufacturers shifting their manufacturing capacity to be able to produce products that can help address the COVID-19 crisis. One of the things that strikes me as a lawyer who handles products liability claims and tort claims is that in doing so, the manufacturers who are acting as good Samaritans and are managing to do this to help with the crisis and keep their employees fully engaged do need to bear some thought as to whether what they are doing would expose them down the line to some kind of product liability claims. We don't have time in this webinar to go into a full analysis of strict product liability against breach of implied warranty and negligence and all of that, but suffice it to say that as a general rule, if you are a manufacturer or a product dealer and you sell a product in a defective condition, you can be held liable from an injury that results from the use of that product when the product is used for its intended or reasonably foreseeable purpose. So it's very important when you're thinking about doing these things to help out and shift and put these new products into the marketplace and into the stream of commerce that you are thinking as a manufacturer. Have we designed this product such that we're confident it'll work for the intended use? Is our manufacturing process such that we are manufacturing this product so it will comply with what we have designed it to do? And are we complying with fully advising purchasers or end users of this product about the nature of the product, how to use it, and the potential limitations of the product? The easiest thing to cite in having any conceptualization of this are the N95 masks. A lot of people throw around the term N95 mask. It's a very specific set of standards that are promulgated by the National Institute for Occupational Safety and Health. And what makes an N95 mask is that it meets those standards. So I use that as a very convenient example to say that if you are manufacturing a product, you want to make sure it really is able to comply with what the end users are expecting it will comply with. There's lots more I could talk about with that, but we've got a lot of other topics we got to get to. So by all means, contact your bond attorney or me offline if you want to have a discussion about that with any products that your company may be manufacturing or sourcing. Thanks. With that, I'll turn it back over to Pete.
Rick, thanks. And just real quick, maybe this face covering example is a good example I don't think anybody thinks that when they're providing a face covering, when face coverings don't otherwise exist, that it's to any particular standard. So I would assume that, to the extent that employers are providing these things or manufacturers are making things, that there would be a disclaimer that this is just a face covering. It is what it is. It may help some, but it's not, targeted to any particular standard. Is that the kind of thing you have in mind?
Yes, that's correct, Pete. And if I may, just for about a 10 seconds here, as it so happens, when the COVID-19 crisis hit, I happen to have one of these standard dust masks that was sold by a home improvement store that I wear when I apply mulch outside my house every spring. I have a very clear understanding that is not a mask that is designed to meet the N95 standards. But the manufacturers of that mask were very clear in labeling it on the packaging that this is not designed to meet that N95 standard. What Pete is saying is absolutely right. We're in an age now where there's encouragement to make cotton masks and masks that simply provide some kind of barrier. I think there is kind of an understanding now that as a society we're addressing that, and that masks may not measure up to the N95 standard. The reason I use that example is because it's a very convenient one, where there is an industry standards organization and there's a process to meet that standard. So, but I agree with Pete. I think at this instance, there seems to certainly be a societal knowledge now that we're making masks out of bandanas, and these are not necessarily intended to go into operating rooms or a medical treatment setting.
Thanks, Rick. Let's turn now to Erica. Erica Wood is a practitioner in our Albany office. She has expertise in tax and finance issues, and she's going to spend a few minutes telling us about the Main Street Lending Program.
Yeah, so I'm going to switch gears totally from the labor and liability perspective and talk about how hopefully you can obtain some loans that, potentially could help your business. Many people have heard about and been asking about the Paycheck Protection Program or the Disaster Loan Program. Both were implemented as part of the CARES Act. I'm going to talk about yet a third program that hasn't got a lot of talk, and that's because we don't know much about it, although I'm going to talk through some of the basics. We know this because the Federal Reserve, who is really the backstop for this program, issued some preliminary high-level guidance on April 9th. They have a comment period that's open until the 16th, so I think you'll see some of the terms firm up then. But in the meantime, it's a $600 billion program. Who's eligible? It's a really broad spectrum right now. The standards are that you have less than 10,000 employees, or that your annual revenue of 2019 was less than 2.5 billion. So obviously there's a huge number of businesses that we can think of that fall within that standard, to be determined whether, there's some additional criteria, but that's what we know right now. What generally is the loan? It has a lot of the same policy drivers as the Paycheck Protection Program and as the EIDL loan. It's to keep businesses that were previously, pre-COVID in a good financial position, keep them afloat and give them an opportunity to maintain working capital and servicing their payroll. So the terms thrown out there right now are a 4-year term. There's no principal and interest payments for a year, an adjustable interest rate, so that'll be a floating rate set from probably prime rate that's usually posted in the Wall Street Journal, with an adjustment from a few basis points depending on where they land. The minimum principal amount is $1 million, and the maximum principal amount is $25 million, or for highly levered businesses, there's a EBITDA leverage ratio that's applied that may limit the amount they're able to take out. You can use these loans to refinance existing capital as well. And then I'll just note, because as I said, there's going to be some developments, so I'm sure we can have another segment on this loan program. is that these loans will come with some restrictions, including restrictions on issuing dividends to common stock, certifications to maintain payroll similar to the Paycheck Protection Program, restrictions on generally purchasing liquid stocks on the stock market, and restrictions on ability to pay down current debt. So that, as I said, we'll be developing. We'll see more, but something to put on your radar as you're, running your numbers and looking for additional cash flow for businesses.
Erica, thanks. And it is 12:45, which is our allotted time. People have informed us that they like this. They like this timing. So we're gonna wrap it up now. I will say we got some questions on the leave issues. Aaron covered the overview, but look for some guidance on that. I think we'll put out another document on that. We got some questions about the face covering issue. A lot of questions about that. We're going to put out another document on that, guidance on that. Erica's topic, we did have some questions, on the loan forgiveness under the payroll protection program. And I'm sure there's going to be a lot of questions about the loan forgiveness program. So look for some guidance on that as well. Thank you, everyone, for being with us today. We really appreciate it. Thanks to our clients and our friends. Everybody stay safe and have a good day.